5 minutes past 10, our talkback lawyer David Whiting is here to help you with free legal advice, as he does at 10 o'clock on a Tuesday every week. 1300 222 774 if you'd like to join in. 1300 222 774 for questions needing free legal advice to David Whiting. Morning to you, David.
Good morning, John.
Anything happened in the law this week?
Well, something happened in London a couple of weeks ago that answered a question that I didn't know I needed the answer to, but quite pleased I've got it.
Yes.
All right. And it concerns gambling and cheating and dishonesty.
Gambling, cheating
and dishonesty.
And dishonesty, they've got nothing to do with each other.
No. Well, the question, this is a professional gambler who goes gambling and he plays a game called Punto Banco.
Called what?
Punto Banco.
Okay.
I have absolutely no idea what it is, but it's a card game.
One of those discreet gentlemen's clubs turned into casinos.
Baccarat or Chemin-de-Fer or whatever it is, but yes, yeah. And it was, in fact, one of those, one of the majors. And in this particular situation, they had a set of cards. And while they looked identical at a first glance, the backs of the cards were not identical. There were slight differences depending on whether they were in the top half of the number range or the bottom half.
What, the cards supplied by the house?
The cards supplied by the house were not perfectly identical. They were substantially identical, but not perfectly identical.
So to the ordinary observer, in other words, the casual...
Like a mug like me, yes.
To the customer...
Should I ever go to such a place? Yep.
The customers would think the cards were all the same, but to the croupiers, they could tell which ones were high numbers and which ones were low numbers.
Except this wasn't a croupier. I wouldn't be upset if it was the house man. This was the non-house man.
Right.
And the non-house man did a thing called edge sorting.
What?
Edge sorting is you're looking at the edge of the card
and
you'll work out whether it's likely to be upper range card or a lower range card.
Okay.
And that makes it easier for you to work out whether you will or will not bet.
Right.
Now, in this particular case, he won, if that's the right word for it, £11 million, which is an extraordinary amount of money to win in a card game.
Depends how much you're wagering, I suppose.
Well, yeah, okay, it's still a lot of money, at least in my world, right? Yeah. And he then, they said, thank you very much, but we're not going to pay you.
What?
And so he took them to court, and the question that the court had to determine was whether or not, what was cheating and whether dishonesty was an essential element. So they came along and they said...
on whose behalf? By the house, you mean?
The question that the court had to decide, their argument was that he was cheating because he was more or less counting cards.
Because he knew the secret code on the face of the cards.
Yeah, effectively. He didn't tell you what the card was. He just told you what it was more likely to be. Yep. Yes. So he then sues the house and
to collect his £11 million.
To collect his £11 million, and it goes all the way to the Supreme Court in the UK, which is their highest court. Mm-hmm. And so there's a question of, well, first of all, what's cheating? The second question is dishonesty an element of cheating? And the court found that cheating was breaching the implied contract between the gamer and the house, that this is in fact a game of chance, right?
So if you're stacking the deck, literally.
So if you are in fact counting the cards or edge sorting, then that constitutes cheating because it's breaking the rules of the card game, as it were.
Yep.
The implied rules of the card game. And then they also had to say, well, but what if he's not dishonest in what he's doing? And they were able to say that dishonesty is not an element of the concept of cheating.
Why do you cheat then?
No, you cheat to make more money.
Yes.
But what you're doing, look, it's an attempt. I mean, we all know that all of the games run by casinos have a margin in favour of the house that might be large or small.
Yeah.
And there are a significant number of people who put an awful amount of effort into coming up with systems or devices that in fact try and move the same margin in their favour.
Even by a tiny amount.
Yes. Well, they're factually fine margins. The casinos make their money out of volume, not on the even hand. So what he's done is he's come along and he's found a technique that enables him to make, by edge sorting, by looking really carefully at the cards and working out what they are, he's in fact able to move the margin from the house to him. And then the question was, well, can you cheat? Is it cheating? The answer was, in this particular case, yes, it was cheating because you're changing the implied terms of the contract. And then the question had to be decided, well, but what if he wasn't doing it dishonestly? He hadn't broken the contract, and the court found we're prepared to say that dishonesty is not an essential element of the concept of cheating, but in this case we do find that there was cheating, there was dishonesty. So you lost twice.
All right. Anything local? There's only one thing that I've found that's remarkable, which was in the Supreme Court yesterday. A man called Dimitris Gargasoulis has been charged with multiple counts of murder and attempted murder in relation to an incident in Burke Street some time ago.
Yep.
And Mr Gargasoulis's case is being case managed by Justice Lex Lasry in the Supreme Court, who, even though the matter's not yet committed for trial, he said, I'm going to case manage this because of the magnitude of it. Victoria Police have said that they have 900 witness statements.
Yes. Yep. A significant portion of the people who were present in Burke Street.
1,100 pages of documents in one part of the brief.
Wow.
And the judge had reason to say in court yesterday, I can assure you 900 witnesses are not going to be called, so you better pare it down. And the Justice Department are refusing to provide the defence with the complete medical records of their client, their own client. They're releasing 150 pages at a time out of 1,000 pages.
Why?
They say it's because of privacy concerns for anyone who might be incidentally referred to, page by page by page.
Yes.
And this is therefore taking months and months just for the defence to get access to their own client's medical history before they can then have their own client referred off for independent advice on whether, for instance, there should be a plea of insanity entered or unfit to plead even to insanity, which are the two options that have been publicly expressed. So all I'm doing here is passing on what's been said in court. There are suppression orders in relation to other matters, but it is an extreme sense of frustration that characterises the incredible snail-like progress of this matter through the courts.
I'm amazed, John, that it's taking that there would be. I understand that they may well have taken 900 witness statements,
not all of which are in fact going
relevant
to have any bearing
or germane to the issues that need to be determined.
And given that the issues are not anything other than whether he is fit to plead or unfit to plead.
Well, that's the preliminary issue, isn't it? I suppose, though, the question then becomes is that the fit to plead question and the commencement of the trial need to be proximate. There's no point having a fit to plead argument today and a trial in a year and a half's time.
A year and a half would be good on the way the judge sees it.
Because the question you have to ask again, because you then need to ask if he's now fit to plead.
There are other issues. So it's a case that for a lot of reasons is going to attract a lot of scrutiny.
Yeah, I'm just, again, the answer is these are the... But I suppose then the question is, I've got 900 witness statements. Here are the 60 witnesses I'm going to rely on. But the obligation is that you've actually got from the brief requirements in the system require you to provide to the defence everything you've got. Not just everything you're going to use, but everything you've got.
So some, as they're called, bureaucrats in the Justice Department are at the moment the very narrow pipe through which everything has to flow, and the judge, along with others, expressing great frustration. Anything else, or we'll get to today's callers?
Oh, sorry, I had Nick from Northcote.
Yeah.
And Nick from Northcote had a building issue. The neighbour next door pulled down the house, built 2 units. In order to undertake the work, what they did was, while Nick was away, was they took his fence down.
Yes.
And trampled his garden, did work from there and caused some damage to his roof.
Yes.
And the question is, who's liable? Well, the answer is it's the builder that's liable. So it's the builder who was engaged for the work is the person who has the responsibility. I would probably be making a complaint to the Victorian Building Authority about the actions of the building surveyor because the work couldn't be properly done other than from Nick's side of the fence, and in the circumstances there should have been a protection works notice and a licence for accessing the premises.
Text message that the situation you described in that court case at the casino, that's apparently the plot of a film.
Oh, okay. It's still a case.
Helen in Watsonia, good morning to you.
Hi, John. Thank you very much for taking my call.
Go right ahead.
Far ahead.
Hi, David. Approximately 4 months ago, my dog broke lead when a car backfired, and he went out in front of another car. And he was hit and dragged. She was hit and dragged for about 30 metres under the vehicle.
Yes.
They were unable to start the vehicle. A tow truck had to be called. We were since contacted by the lady's insurance company to say that we were liable for the replacement of her car because it was deemed not suitable to go back on the road.
Yes.
At that stage, we knew it was a Ford Focus 2011 model. It took several months, and only just last week we received a bill from them stating we had to pay close to $8,000 damages to the person whose car my dog had, gone underneath. A little bit frustrated with the whole process because we didn't get to even look at a claim. We didn't get to, have a review. They just took the car, they took it to their people, they wrote it off, and they sold the car to a dealer for $2,000.
Yes.
And we have to pay the replacement costs. And whilst we accept that we've done that, it's when we went to our insurance company, they said we weren't covered.
Are you covered by your household insurance?
We contacted our household insurance, and they said we should have, unbeknownst to us, there was an option that we had to tick, and we never heard about it. And it's only a small amount of money over the year. So we're left with a very threatening letter from an insurance company saying, pay this bill in 14 days or else.
Well, there are really two parts to this, Helen. The first is the liability, the second is the amount.
Yeah.
My view is that the insurance company doesn't know whether you're going to pay or not pay.
Okay.
So I would have thought that 99 times out of 100, the amount that the insurance company tries to recover from you is the fair and reasonable loss and damage, because they paid it. They paid it probably within a month of the accident.
Okay.
And so the question, though, the interesting question is that it's, do you still have the lead?
The lead the dog was on?
Yes. The reason why I ask is that do you remember we every now and then you get a call that did you breach your obligation? I mean, did you know that was your lead strong enough normally? Was there a reason why you would think it was going to fail? I would have thought not. I mean, you wonder whether we talk in the law about a bee sting. Every now and then you'll find that someone will argue that they're driving down the road, a bee came through the window, stung them in the eye, they swerved off the road, they hit something, and therefore they weren't negligent. What happened was there was an intervening act, the intervening act being the bee sting. I mean, your intervening act might be the backfire.
Yes.
But it's not a strong argument.
No.
It might be one that you'd run, but I wouldn't be spending thousands putting it.
No, and that's what we can't afford to fight it. We can't afford to really pay it out in one go either.
Well, insurance companies will often agree to an instalment arrangement if you can satisfy them that that's the only way you can meet the bill.
Okay.
All right.
Okay. Wonderful. Thank you very much.
Thank you, and I'm sorry about you. How's the dog?
Oh, she's. I looked after her for about a month with dressings, and she's recovered.
Okay,
excellent
costly,
news.
But she's
well,
recovered.
That's one positive.
Absolutely.
Thank you, Helen.
Thank you very much for your time today. Bye.
Bye-bye.
Good luck with that. Judy's called from rural Victoria. Hello, Judy. Welcome.
Oh, thank you for taking my call. I just want to turn off this radio. It's been quite...
So long as it's something other than the ABC, that's probably okay, Judy.
No matter what it is.
I'm listening to the ABC. I'm a great fan of... He makes me mad sometimes, but I'd be in tears if he ever left the program.
You're clearly talking to John, not me, aren't you, Judy? Yep.
Yeah, I'm talking to John,
Okay.
and I hope you're listening. John, I'm a transgender person. I'm in a large regional city just outside Melbourne. I've had cancer in the past, and I'm in a great deal of pain. I've got a lump in my stomach, and I'm very, very weak. I'm too weak to sit up. I find it very, very difficult to walk.
I'm sorry to hear all of that, Judy.
No, that's fine. I've had 2 referrals. One doctor has referred me twice to a major hospital down in Melbourne.
Right.
She said it's really good and they're the best hospital to go to.
Yeah.
She didn't get a reply. And my local doctor here, the one I normally see, unfortunately I can only see. He only works twice a week here.
This is your consulting specialist, is it, Judy?
No, this is my GP.
Yep.
He has also referred me down there. It's been going on for about 8 months now, and what happens is I just keep being referred on. Nothing happens. I get referred here, I get referred there, and it's just like...
Judy, when you get a referral, don't you go and make an appointment based on the referral?
I get referred to another department inside the hospital.
Yes.
They make an appointment, and when I get a letter in the mail, and it's quite often a couple of months away,
So what do you want David to help you with today, Judy? Because I'm not sure how this is a legal issue.
They are using the old public service thing of just obscurating. They will not treat me. I'm
Judy,
in terrible pain at the moment. I know there's something wrong. I just can't get treatment. I tell them I'm in pain, and it's like they're not listening, and I am in pain. I am scared.
Okay, let's get you some advice, Judy.
Judy, I would be talking to the Health Services Ombudsman, and I would probably be addressing the complaint in relation to the hospital rather than the medical practitioner you've been referred to, because it sounds from what you're saying is that you're getting a significant runaround from the hospital, and so your issue is, in a sense, the way the hospital is dealing or not dealing with your issue. Health Services Ombudsman, and I find them to be remarkably efficient.
Do you know how to do that? How to get in touch with them, Judy? Every hospital, including the one in the country, will have a complaints officer who can help you navigate that path.
With respect, John, I have tried that, and my first complaint was on discrimination.
Right.
They denied it, so therefore the person from Equal Opportunity said, we can't do anything more. They denied it.
No, I'm not asking you to Equal Opportunities.
Hang on. I went to the Health Ombudsman, that organisation that John likes to talk about. They said it wasn't their role to make me feel safe in hospital, because I inadvertently said to them while I was talking to them, I just want to feel safe when I go to hospital. And she said, and then I got a letter in the mail a couple of weeks later saying it was not their role to make me feel safe.
All right. Is there anywhere else that Judy can go to, David, that you can think of?
John,
Yes, still
understand.
here.
I'm in pain now.
I understand that, Judy, and that's why we're trying, with David's advice, to see where else, if anywhere, you could direct your inquiry. So let's just see.
I would be going back to the Health Ombudsman, but I understand your I want to feel safe, but the answer, the primary issue is that I have a need for treatment. Presumably you can get a copy of the referral that your GP has provided to the specialist or hospital, and that's the basis of the complaint. I have this problem, I need this treatment, and nobody will provide it to me. Why won't the hospital take the referral? Why won't they deal with it?
Judy, I don't have a magic wand, but I think that's about as much as we can cover on the radio today.
I wish I was strong enough to. We've been trying for 8 months.
I understand that.
And talked to them on numerous occasions.
But Judy, I might say there are lots of people who don't get satisfaction through the health system. That's why this system has been set up. But I'm not sure there's much else David can help you with on the radio today.
So I just go without treatment.
No, I'm not suggesting that, but I'm not sure David is the person whose advice is going to make any difference. I think you should continue to talk to your health providers at the very places where you're being treated rather than get the brush off. But I'm not sure David's got a magic wand for you on the talkback today. I'm sorry.
John, I haven't got another 8 months. I'm sick. I'm so sick. I can't sit down at a computer and write a letter anymore.
Judy, I'm more than sympathetic, but I'm just aware that there's a lot of other people waiting for advice. We're not able to provide you with any magic solution today, and I'm sorry. I think that's all we can do for you today. All righty? I'm sorry. Chris in Mount Waverley, good morning to you.
Hi, John and David.
Chris.
First-time caller, so I'll launch into it.
Good.
Estate property, Dad's house, was valued by Property Valuer October 2016 for a historical value date of Yeah, a bit confused there. So Dad passed away July 2016,
Yes.
and the property valuer inspected October 2016 and backdated it to
Gave you a
July.
value as at July 2016, yes?
Yeah.
Yep.
So Supreme Court granted probate on this value in November 2016.
Yes.
And just now, as at now, or a couple of months ago, legal tell us we need a new market value. Is that correct?
I don't know. I don't know what's happening to the property.
Yeah, so my sister's involved, and my intention is to take over the property. The will says 50-50 split of the assets.
Yes.
So, yeah.
Well, I think, Chris, are you an executor, Chris?
Yes,
Okay.
joint
Is your
executive.
with your sister?
Yeah.
Okay. Here's the deal. You can't take over the property without your sister's consent.
Yeah.
Right? The rules, unless the will says something different, an executor can't acquire an estate asset without the consent of the other beneficiaries. Now,
Yeah, so verbally
your sister,
she's...
sorry, Chris, your sister today is entitled to half the value of the estate.
Yep.
Now, and if you want it today, it's half today's value. It's not half last July's value or last October's value.
Even though probate was on that historical value. And
hang on, no. I've never understood what the purpose of an inventory was in a probate application. But what you do is you go to the court and you say, this person has died, here's the death certificate, here's the will, and here's what they had. Okay? Now, you are now negotiating with your sister to take the property as part of your share of the estate.
Yeah.
What I don't understand is why you would expect to buy it or acquire it in last July's value. Why would you expect to acquire the property in a value that's 14 months old?
Let's say, for instance, it consisted of Bitcoin, Chris, which have gone up hugely in the interim. You wouldn't want to be missing out on the uplift in value since the last valuation.
Isn't everything struck on the date of passing?
No, what it is it's a historic record. It's a historic record in the same way as it was what the property was worth when your father bought it.
And just think, if you were on the other side of this, Chris, would you be happy to take a valuation for your share from so many months ago? You probably wouldn't.
So let's assume the property's gone up $100,000 in value in the 15 months.
Yep.
And you were selling to your sister. Would you be prepared to walk away from the $50,000 uplift? Maybe you would, but she doesn't have to.
I'm annoyed that legal are only telling us this now. Why didn't they tell us when we had the property valuer?
Because in October 2016, he wouldn't have been able to tell you the value of the property in November 2017.
But they should have told you it will need to be revalued along the way.
No, that only depends, John, on when Chris and his sister agreed that he could acquire the property.
So if they'd agreed back then, that would have been the valuation, but they've taken so long to reach
agreed
an
and implemented back then, not just agreed.
Yeah.
All right?
Okay, Chris?
Yeah. Okay.
Thanks,
John.
Does that help you understand the process?
Yeah,
Okay.
That helps.
All righty. Greta in Brunswick, before the news headlines. Can we keep you going a little bit longer after the headlines,
sure.
David? Because we've had some complex matters today. Greta, good morning to you.
Good morning, John. Good morning, David. I'm just calling because I got an infringement notice for driving my car unregistered. However, I wasn't aware it was unregistered at the time. I only got my reminder notice after the fact. It arrived like 2 weeks after the due date.
Greta, do you want the bad news?
Yes,
There is absolutely no excuse.
Really?
There is under the legislation, they have no obligation to send you a reminder.
Okay.
It is up to you to know when the registration falls due, and it's up to you to know whether it's paid or not.
Every single one of us now has that obligation.
Mm-hmm. John and I had a discussion with John suggesting that you might put a sticker on your window that reminds you the month and year when it falls due for renewal.
And there's lots and lots of people who move house and forget to notify Vic Roads, and then they don't get their renewal when it comes in the mail. Yeah. And suddenly they don't even realise until they get pulled over by the police that they're driving an unregistered car, and you're one of many caught this way, Greta.
So one of the things they did that was clever about 20 years ago, John, was they decided to link your car registration to your driver's licence.
Yep.
Because you're quite likely to update your driver's licence and ignore your registration.
Although it
follows you.
But I think your driver's licence is issued for years and years at a time now,
It is,
isn't
but you have an obligation to change it within 3 months of moving.
If you move, yes.
Yes.
Okay.
Sorry, Greta.
So I have no grounds for appeal, that's all.
No, well, certainly you might have grounds for appeal, but grounds for appeal are not, I didn't get it.
Yeah,
Okay.
right.
Thank you.
Okay, cool. Thanks so much. Good
And
night.
some more, 1300 222 774, more calls with David Whiting after the news headlines, which Kate Draper has for us just after 10:30. Thank you, Kate. Back to callers. David Whiting generously has agreed to help out a little more this morning. We've had some complex and time-consuming matters, so we haven't got through that many. Lots of people texting in saying to our last caller, it was Greta, saying that put a reminder, like a birthday date reminder, into your calendar, whether it's digital or just a paper calendar, and put a reminder in so that, like you don't forget birthdays, you don't forget car renewal as well. Fred in Sunshine, thank you for holding on, and good morning to you too.
Thanks, David and John. Also a first-time caller.
Doubly welcome.
My mother recently deceased. I went to the viewing of the will. Present was my sisters and myself and lawyer, but my brother was absent. I became very suspicious of my sisters on why would my mother renew the will on the 17th of May 2012 at the age of 92. When I remember her saying to me she left the house and the remaining assets to myself and one of my sisters, and the others two members would not be included because they'd done very well out of her husband land grab, which caused a massive family rift. I requested for the previous will, which I received, and it was true.
So your mother changed her will in 1992, in 2002.
Yeah, and 92, and it included. It would just go, and also I wanted to see what the previous will said, and it had stated what I just said, that the house and the remaining would go to my sisters, but she did it. She did that will on the 6th of September 2006. My question is, my brother was excluded, but my sister was included. How could I challenge the current will to revert to the previous will, which is more just, which when I say this is only crumbs
Fred.
Yes.
Your mother has the right to write a will any way she likes.
That's right,
okay?
Yes.
So there are two possible challenges to the will. Right?
Yes.
The first challenge is to argue that the will doesn't provide adequately for you because of your circumstances relative to everybody. Your circumstances.
No. My circumstance is very relevant to me.
No. Of course, they're relevant to you.
Yeah.
But your first argument is that the will doesn't provide adequately for you. All right? Which isn't the same as she promised it to me 15 years ago. It's really coming along and saying, having regard to my circumstances, my ability to earn a living, my needs, the will doesn't provide adequately for me. And the court will listen to what you have to say and will take into account how the will provides for other people as well. So they'll need to look at everyone else. Now, and that's called a claim for further provision for the will. The second claim is, and it's really in the alternative, is that the will that your mother signed in 2012 was defective because either she didn't properly understand and therefore it wasn't her will, or she was bullied into making it and therefore it wasn't her will.
That's right. Yes.
Now they're really, really hard to prove.
Yeah, I know.
Not impossible, but really hard. Yeah. So your better argument would appear to be that your mother's will didn't provide adequately for you.
Yeah, but the thing is, David, because what are the probabilities of challenging the current will, because
on what basis, Fred?
David, if I had a little victory, I would donate the portion of one of my sisters to charity.
No.
Dipping. She's already received a massive payout from the previous estate.
Fred, what you're going to need to do is sit down with a lawyer, and you're going to need to go through the will, the position in every other family member,
the previous
and your
estate
position
that Fred's talking about.
Yeah, so,
yes.
if they've all got, so mum and dad, but some of the kids got everything from mum in the expectation it was going to come, everything that they got from dad on the basis that Fred would be looked after from mum. So, all of those things are relevant.
And beyond the scope of dealing with it on the radio in a quick conversation.
Well, it's not a 5-minute conversation.
No, it's a couple of hours worth of going through meticulously the full family history. Okay, Fred, you need to get some advice.
Good on you. Thank you very much,
Thank you, Fred.
All righty, and thank you. Lots of text messages from people. Apparently, there is a Vic Roads facility on their website, David, which allows you to check your registration in order to establish when it's due, and you can link to get a reminder sent to you via email and have it automatically added to your digital calendar. But the idea of getting an email reminder from Vic Roads by doing a search on your own car rego is
I want your mobile number. I'm very fussy about who I give my mobile number to.
Oh, okay. Well,
the thought of giving it to Vic Roads does nothing for me.
Give them another number rather than yours. They don't know the difference.
Okay.
Just give them a number.
Yep.
That's enough to get through their filter, and then you'll get the email confirmation.
Yeah, just feel very sorry if, say, David Whiting's car registration is due.
No, I actually have a sacrificial prepaid mobile, which I use for
such occasions.
Well, when I'm, for instance, if I'm advertising to sell an old car or something,
yes,
and I don't want to give out my personal mobile to the world.
Have you got a dealer's license yet, John?
No, it's about once a year, and you don't want to put your personal mobile out, then you've got a prepaid, and you just sort of keep $10 credit on it.
Okay.
So I don't know. I'm just giving you.
No, that's a good one. Yep.
Yeah.
Thank you, John.
Thank you, David, and thank you for staying on and helping people above and beyond. And there are people still waiting, and I'm sorry. That's sort of always my apology and my lament. But David will be back next week and able to assist you with free legal advice then. 1300 222 774 if you want free legal advice next week when David Whiting joins us. But I'm afraid that's all there's time for today.